you cannot, if you are not a member of that party, you can't complain about whatever transpired during the nomination of a candidate. So PDP and Labour seeking to stop Tinubu and Shettima on the basis that Shettima was not validly nominated, or that Shettima was guilty of double nomination, was dead on arrival from the beginning, because they didn't have the local standard to even bring up that matter in the first place. It was a misreading of Section 185 14C. They clearly misread that portion of the Constitution. And Justice Ogunwumiju, one of the Supreme Court justices that sat on this matter, I want to read what she said, because she had earlier resolved the matter involving Uche Nwosu. Uche Nwosu was guilty of double nomination. And Justice Ogunwumiju affirmed that the cases, that case and this particular one were different, because they kept citing Uche Nwosu. And Justice Ogunwumiju was the one who read the lead judgment in Uche Nwosu's matter. And the judge said, no, these are two different cases. Uche Nwosu was was governorship candidate of both the APC and the AA. In the case of Tinubu, it's not a case of somebody being, in the case of Shettima, it's not a case of somebody being nominated on two different platforms. This person became the candidate of the party for a senatorial election. And the moment he was picked by the president-elect as his running mate, back then, he dropped the senatorial ticket. Now, let me read what Justice Ogunwumiju said so that we can have clarity. The moment the fourth respondent submitted his withdrawal to his political party, his nomination stood withdrawn. Exhibit 6, relied upon by the appellant, dated 15th July 2022, was the date the fourth respondent was substituted by INEC and not the day he was nominated. There was no double or multiple nomination. As the withdrawal and notification by the fourth respondent and the second respondent to the INEC is in line with Section 31 of the Electoral Act 2022. So you can see Justice Ogunwumiju's argument, and she has clarity on that matter because she had decided a similar matter in the past involving Uche Nwosu, who was a candidate of both the AA and the APC in Imo State back then. Then Justice Adamu Jauro, Justice of the Supreme Court, read the lead judgment and listened to him. The appellant is a nosy busybody and a meddlesome interloper without local standard to challenge the nominations of the APC candidates. The case is fraught with irredeemable maladies and it is without merit. The appellant asks us to hear the matter on merit. There are conditions for invoking Section 22 of the Supreme Court Act. The trial court, and indeed the court below, no longer have jurisdiction, and this court cannot assume jurisdiction as these are constitutional provisions. The court is a court of policy and must maintain its integrity. Justice Okoro, on his part, was very angry about the way the social media was used to terrorize, in his words, the judiciary, the Supreme Court judges. Whereas, in his words, the lawyers to the appellant clearly misled the court and misled the people. So Justice Okoro says using the social media to terrorize and bully the justices of the Supreme Court by the appellant is appalling and unprofessional. The appeal is without merit and it is dismissed. He also affirmed, okay, I think it was Justice Ogunwumiji who said a decision is authority for what it decides. He was referring to a case that she earlier decided. So clearly, Section 285, subsection 14, okay, that was the one I call Section 185. Section 285, subsection 14C is being misunderstood. The Supreme Court affirmed that only applies to political parties challenging INEC, that it does not permit a political party to get involved in nomination of candidates in another party. So the law is clear, both in the Constitution and the Electoral Act, as well as Section 29(5) of the Electoral Act, that you cannot get involved in the internal matters of another political party. Remember, even in Benue, Father Alia's emergence as the candidate of the APC was challenged by the PDP. And this was the same matter, this was the same way it was decided. The Supreme Court ordered the appellant to withdraw the matter. And when Supreme Court tells you withdraw the matter, that means your matter has been dismissed. That's another word for dismissal. So in future, you can't bring this up, and this matter has been laid to rest. Kashim Shettima was not guilty of double nomination because the court also looks at intention. The moment you wrote the letter saying, look, I'm not interested in the senatorial contest anymore, you have said clearly that you are not interested. And just like Justice Ogunwumiji said, Shettima did not get involved in any primaries for the post of vice president. It was the president-elect now that nominated him. Aouje referred to what happened to Atiku in 1999. Atiku had won election as governor of Adamawa State before Obasanjo picked him as his running mate. And Atiku became running mate to Obasanjo. Nobody accused him of double nomination. And according to Justice Amina Oge, the matter came to the Supreme Court. They wanted Atiku's deputy to not step into his position, but the court ruled that Boni Haruna, as running mate to Atiku, would be, automatically becomes the governor. Since it's a joint ticket, both of them had won election, so he naturally stepped into Atiku's shoes after Atiku became running mate to Obasanjo. So if Atiku was not disqualified at that time, why should Atiku, who had benefited in the past from this kind of situation, be pushing to have Kashim Shettima disqualified just because somebody appointed him as his deputy? Somebody nominated him. He didn't get involved in the primary election. So it's just similar now to the case. You know, all of these cases are coming up. Those who came together in Abuja and said, oh, Tinubu did not score 25%. You cannot challenge the outcome of the presidential election if you were not a participant in that election. The people can challenge Tinubu's victory are the people who contested against him. That's what the law says. Otherwise, even you, Shita, you can get up now and say, oh, I do not like the outcome of the election, I'm going to court. Not all of us can't challenge the outcome of the election. It's the people who lost the election who can feel aggrieved, who can complain about the process leading to Tinubu's victory and then decide to go to court. So the people who have the power to go to court are the OBs. Obi came third, and he thinks that he's the one who won the election, he's gone to the tribunal. Good luck to him. Atiku, a perennial litigant, also believed that Tinubu did not win the election. He's gone to the tribunal. Good luck to him. After 180 days and then 60 days, totaling about roughly 8 months, we will know who indeed won that election, because the Supreme Court will have decided on the matter, and the matter will be laid to rest. So there are so many cases that coming up, some of them frivolous, and I think the lawyers, the judges have to descend on the lawyers who are bringing these funny cases and wasting the time of the court.